So what do you do if you have a workers' comp case? So this would be a case that's going to trial, and there's some detail, skeleton in your closet, that if that detail or skeleton or evidence in a medical record is going to be a problem for your case. And because if it's presented to the jury, it might have a negative impact on how they view the evidence in your case. Well, what your attorney might do is they might file what's called a motion in limine, and if there's, and they will make, basically in this motion, they'll explain to the judge why this evidence should not come in. Now here's the thing, just because evidence would make your case harder is not a good reason, is not a reason for the judge to grant the motion in limine, but the judge may grant the motion in limine if the evidence is highly, like, prejudicial in a way that is going to be confusing or mislead the jury, something of that nature. So, for example, or if there's, for example, let me give you an example. Let's say in a medical record, you went to the hospital and you said, hey, this is how I got injured, but for whatever reason, the hospital documented some mechanism of injury that is not correct. And if that information got before the jury might misinterpret that. They might take that what the ER wrote. They might construe that as, oh, well, you said this, but this ER record says this. The jury might wrongly rely upon that and then again rule against you. So one, you could object to that coming in because that would be hearsay, particularly if it says, hey, the injured worker stated this, and that mechanism of injury information has nothing to do with the treatment of that, of that injured worker. So, but you might object to that. Your attorney might object to that anyways. But they also might write a motion in limine. And so again, the other reason why we might write a motion in limine is there's some crime in your past, but it's not a crime that's really impinging upon an issue of honesty or being dishonest or credibility. And so, but it would be very prejudicial if that came in. So you might write a motion in limine saying, hey, this would be very prejudicial. It's not really probative of proving this or that thing. So that would be, maybe the judge would grant the motion in limine, and then that piece of evidence or that testimony would not come in trial, and that might help you win your case. So that's one of the things that what your trial attorney might do is file a motion in limine. They might be doing that in the background. You might not even be aware of this is going on, but that may be happening. And sometimes we do that in these workers' comp trials as well.